How long do you think XRP support will last? How long will the trial last? Will this affect the state of the SEC? We will answer all these questions in today's video. The SEC and Ripple have exchanged documents on one of Ripple's most significant arguments against allegations that it improperly issued unregistered securities in connection with XRP. Ripple, which is fighting the SEC's effort to have the case adjudicated in its favor via summary judgment, is hoping to rely on the fair notice argument. Under U.S. law, a defendant may have an affirmative defense to charges of breaking the law if they can show they did not have reasonable notice that their behavior violated the law, which Ripple claims applies to their XRP offering. However, several recent court judgments concerning the reasonable notice defense imply that it would not apply in Ripple's case. The SEC called the court's attention this week to the most recent of these. SEC versus Commonwealth Equity Serves LC, decided last month and in which the court rejected a fair notice argument made on the identical grounds as Ripple. It specifically ruled that the defendant could not use the fair notice argument since the SEC's accusations were based on a 50-year-old Supreme Court decision. This was true, even though according to the defendant, the SECs had been aware of the improper activity for more than 2 decades. The SEC had been aware of the improper activity for more than 2 decades. In other words, the SEC's reluctance to enforce regulations in the past does not justify violations of same rules in the present. Given that the SEC's argument is similarly founded on decades-old Supreme Court precedent, the Howey test for assessing whether an offering amounts to an investment contract and so constitutes a securities offering, the SECs contended that the court should reach the same result. Ripple responded quickly, informing the court in a document that the Commonwealth case could not be used since the defendants adduced no contemporaneous evidence supporting its defense that market participants lacked fair notice. This, according to Ripple, is in contrast to its own argument, which it claims includes abundant evidence showing reasonable market participants did not think the offer and sale of XRP constituted a securities offering. It further contended that the court in Upton, on which Commonwealth is based, found in favor of the defendant's fair notice argument and that the court in this instance should do the same. According to the judge, Upton was an effort by the SEC to discipline the CFO of a brokerage business for breaching an SEC regulation that established the formula for calculating how much brokerages must keep in a client reserve account. The fair notice argument may apply since the SEC's punishments were based on a unique interpretation of an existing regulation that had not been made public. Instead, the SEC has based its claim on a straightforward application of a venerable Supreme Court precedent that has been applied by hundreds of federal courts across the country over more than 70 years, noted the judge in Elbry. While this is the first time it has been utilized against a digital token issuer that did not hold an ICO, Elbry is in no position to argue that it did not have fair notice that its conduct was illegal. Ripple Labs continues to battle the Securities and Exchange Commission, and their most recent filing is no different, as they immediately respond to the SEC's letter of supplemental authority over the regulator's motion for summary judgment with a confident and forceful rebuttal. The U.S. Securities and Exchange Commission, SEC, recently referenced to a separate enforcement action against investment advice company Commonwealth Equity Services to support its case in the continuing legal struggle between the SEC and Ripple Labs. However, Ripple's legal team has replied quickly, claiming that the reference decision has no bearing on their fair notice position. The SEC's complaint against Ripple Labs, SEC v. Ripple Labs in et al., claims that the business and 2 of its executives, Brad Garlinghouse and Chris Larson, raised more than $1.03 billion in an unregistered continuing digital asset securities offering. One of Ripple's key claims is that the SEC did not give enough notice before to bringing the securities fraud action in December 2020. The SEC wrote to the judge presiding over the matter on April 11, highlighting the Commonwealth finding, which ruled that a long-established court precedent provides enough fair notice The SEC stated that the precedent that led to the formulation of the Howey test provided Ripple Labs with ample notice of what defines a security. The SEC also claimed that their case against Commonwealth gives them more power to invalidate Ripple's fair notice position. However, on April 13, Ripple's legal team submitted a response contending that the Commonwealth decision reference does not offer further justification for dismissing their fair notice position. The letter to District Judge Annalisa Torres highlighted the contrast between the two instances. Ripple's defense emphasized the Commonwealth case's lack of contemporaneous evidence, whereas Ripple's situation involves abundant evidence, including communications from the SEC to third parties, demonstrating that reasonable market participants did not regard Ripple's offers and sales of XRP as investment contracts. Furthermore, Ripple's statement stressed that the key question in their lawsuit is whether the Securities Act applies to their XRP offers and sales. The legal team contended that the SEC's reference to an unbroken chain of district court decisions rejecting fair notice defenses is irrelevant since the court had already rejected the SEC's reliance on such instances. Ripple's defense argued that the closest case, Upton, is binding precedent, and that it found in favor of the defendant's fair notice claim, encouraging the court to do the same. Following the outcome of the Ripple v. SEC lawsuit, XRP is expected to be one of the best performing assets. Ben Armstrong, often known as BitBoy, is a vocal supporter of this story. The famous crypto influencer recently said that the resolution of the legal case will herald a fresh wave of profit for XRP investors who have been patient throughout the experience. On Wednesday, BitBoy turned to Twitter to voice his thoughts, recalling a well-known remark ascribed to several persons, including philosopher Seneca. He suggested that the result of the Ripple v. SEC lawsuit will signal the end of one chapter and the start of another. The Ripple case might be resolved at any time. When one thing comes to an end, it marks the start of something else. In this situation, the new thing is that if you stick with XRP and you will become you will become wealthy. It's almost time for you to grab your rations. According to him, the next chapter will begin with the development of large money for XRP investors who endured the protracted legal processes with the SEC. He urged the XRP army to persevere, declaring that the moment had come to realize the benefits of their dedication. Furthermore, BitBoy said that he expects the Ripple and SEC legal conflict to be resolved shortly. However, the XRP community is skeptical of this claim, since the popular crypto influencer earlier stated that the litigation will conclude in September 2020, a prediction that did not come true. To soothe any doubts, BitBoy admitted that his September 2021 prophecy did not come true. He did, however, clarify that his recent words were not simply forecasts, but rather based on true knowledge, since the trial schedule is likely to complete soon. As previously reported, Attorney John Deaton predicted that a decision will be issued on or about May 6. I love how people are bashing me for claiming that the Ripple case would be resolved shortly. I projected that it will end in September 2020. 1. That's the only time I've ever specified a date. It did not occur. The XRP matter will be resolved shortly. It's not a forecast. Dudes, it's the conclusion of the trial calendar.